Thank you very much, Chairman. Judge Gorsuch, the state of play after our conversation yesterday, as I recall it, is that you would not say that anonymous billionaire dark money is a bad thing in our democracy, and you would not call on the dark money behind the $10 million political campaign for your nomination to reveal itself. Now, if I'm wrong in that recollection, I just wanted to give you a moment to either amend or correct my recollection of those 2 points yesterday.
Thank you, Senator. I believe what I said yesterday is that Congress is the primary organ for lawmaking in our legal order, and that Congress has ample authority an opportunity to pass campaign finance regulation, including disclosure laws. The Buckley versus Vallejo expressly recognizes the power of Congress, especially in the area of disclosure.
And what I was asking you, just to be clear to the point, is whether you saw disclosure as an affirmative value, in the same way, for instance, that you see reliance interests for corporations on the law as an affirmative value.
And Senator, you're mistaken. I never said reliance interests for corporations.
Reliance interests for parties.
That's what I said, Senator. And that's because that's the law, in the law of precedent. We look to reliance interests. And when it comes to the First Amendment,
reliance interests, that's judge-made law. That's the law of precedent.
That's the law of precedent, yes.
Because the judges follow important principles.
Precedent, Senator. We follow precedent.
Which are grounded often in principles. There's more to the law than just what Congress declares, is there not? There's the entire devolution of the Constitution into all of the doctrines that the Supreme Court has parsed it into over the years. That's done without Congress, isn't it?
And one of the precedents of the United States Supreme Court, if you want to call it a principle, I'm not going to argue with you, in Buckley versus Vallejo had to do with disclosure. And the Supreme Court expressly recognized that under the First Amendment, Congress and the states, who've been actually busy in this area, as you know, legislating, have the power to pass laws requiring disclosure up to a point. There comes a point, there is a point that the Supreme Court's also recognized in NAACP, where disclosure can be used as a club.
So let's talk about NAACP for a minute, because twice you reverted to that yesterday. NAACP versus Alabama is the case you have in mind when you say that, I believe, correct?
Yes.
And it suggests, when you raise that in the context of a conversation about dark money, that you find an equivalence between billionaires meddling secretly in our democracy behind a screen of front groups that they've thrown up to obscure their hands, and families in the Jim Crow South whose homes and churches were being bombed, whose sons were being lynched by white mobs in essentially mass racist murders across the South, but particularly in Alabama, in that state, and where the disclosure of their membership in the NAACP would have put them immediately into harm's way. Now, presumably, that is not what you meant. So
Senator,
let me give you a chance to clarify that you don't see those two things as equivalent.
Senator, I never said any such thing, and I wouldn't, and I haven't.
Well, when you
That's
cite the
Senator,
NAACP case, it's hard not to revert to its facts, which were
yes, exactly.
Which were those.
Very important facts.
Yeah.
Every case, every precedent is built around its facts. That's absolutely right. And
so that may not have much application to the case of billionaires secretly meddling in American democracy behind front groups, correct?
Senator, if I might.
Please.
Okay. We were talking about disclosure requirements, as I recall.
And that's where secretly meddling comes in. That's why I used that phrase.
I believe we were talking about disclosure requirements and First Amendment doctrine. And I indicated that Buckley versus Vallejo has given this Congress, if it chooses, the opportunity to pass laws in this area expressly. And all I acknowledged is that there does come a point at which one has to worry at the other end of the spectrum under existing Supreme Court precedent, and that is the NAACP principle. And Senator, that's it. That's all I've said.
Great.
I haven't,
I wanted
and
to make
read
that-
anything else into
I
that
wanted to make that clear.
would be
because
mistaken.
I think there's a very significant difference in the fact.
Of course there is.
Oh, very good. So let me go back into our history a little bit. In 1816, Thomas Jefferson expressed concern about, and I'll quote him here, moneyed corporations which dare already to challenge our government to a trial of strength. And a little bit more than around a century later, Teddy Roosevelt warned, and I'll quote Teddy Roosevelt, that unless the great corporations are controlled by the government, they will themselves completely control the government. Should the Supreme Court, in its decisions, keep in mind Thomas Jefferson's and Teddy Roosevelt's warnings about what can happen when massive economic powers jump the fence to become massive political powers?
Well, Senator, as you know, corporate speech, when it comes to the First Amendment, doesn't receive the same protections as individual speech. There is a difference in the doctrine there. So that's an example, perhaps, of an instantiation in law of some of the concerns you're expressing. Another instantiation or example to me is antitrust law, the Sherman Act, passed by this body and interpreted by the Supreme Court over many years now, trust-busting era stuff. And and it does try to keep competition as an important value in our legal system.
So let me elaborate a little bit on that point, because you have said that before in your decisions in the antitrust realm, that competition is an important value that judges should bear in mind as they're interpreting antitrust law and antitrust precedent. And I agree with you. I think it absolutely is. I think you also said that innovation is another such value, and I agree with you on that, too. My concern is that this Supreme Court right now, at least the Republican-appointed majority recently, particularly the Citizens United group, seems to not admit the possibility that the similar kinds of concentration of power that destroy competition and innovation in the economic market can also take place in the political marketplace and can destroy competition and innovation in the political marketplace. Do you see that principle, that there could be a point where political power is so concentrated that it in effect is crushing the opposition rather than allowing free competition as a potentiality that the court should bear in mind as it makes its decisions?
And Senator, here I think of Buckley again, and its recognition that corruption and the appearance of corruption are legitimate interests that Congress can pursue in legislation. And that is an example of, I think, the principle you're talking about, which Citizens United also speaks of. It says there the record before it didn't satisfy the court that Congress's legislation in that particular case had established a case of corruption. I understand you disagree with that, but it did recognize that corruption in its appearance remains area where Congress may legislate in the future.
So let's go to that point, because they did say that no amount of corporate spending, none, there is no limit on the amount of corporate spending in politics that could lead to either corruption or the appearance of corruption. To me, that is fanciful in the extreme. And they got to that point with three, well, I would say they did fact-finding, which they're not supposed to do, but I don't want to quarrel over that point with you here, because that's not the point of my question. So let's say what they did was they made some presumptions. One presumption that they made was that all this corporate political spending they unleashed was going to be independent of candidates. That was presumption one. Presumption two was that it was all going to be transparent. ExxonMobil was going to put up the ad saying, we hate Whitehouse because he's fighting us on climate change, and you should be with us, and everybody would know who the players were. The third is that the back and forth that this would produce would not affect confidence in government. Now, I think that the facts, reality, as it has developed since the Citizens United decision, completely belies all three of those points. All of the major candidates for, at least most of the major candidates in the last presidential election had what they called affiliated super PACs. I mean, what does affiliated mean? It does not mean independent. So clearly, just on that alone, it doesn't even pass the dictionary test. Clearly, there's no independence. As to transparency, this whole dark money problem belies their assumption of transparency. And public confidence has crashed in government since that decision. For, among other reasons, I think when you are sitting there looking at the TV and an ad comes on that says, vote for Senator Snooks or vote against Senator Snooks, and this ad is brought to you by Americans for Puppies and Prosperity, and everybody looks around and they know perfectly damn well there is no such real thing as Americans for Puppies and Prosperity. There's no real corporation running that. There's no real person running that. It's a screen. It's a front. It's a shell for the real actors behind it. I think that is very damaging to Americans' confidence in their government on both sides of the aisle, which I think is one of the reasons why all three of the major commentators on the Supreme Court have basically described them in the modern age now as instruments of the Republican Party. And I think it also is why the majority of Americans looking at the Supreme Court think they won't get a fair shake there against a corporation. In fact, 36%, more than a third, think that the court will be much more favorable to a corporation than to a person. So the question here for you is, would you be willing, if you came to the conclusion that the independence presumption or the transparency presumption or the confidence presumption of Citizens United were in fact wrong, to reconsider that case?
Senator, I've got a couple of reactions to that, if I might.
But don't lose the answer to my question.
No, I'm going to start with that, but there's one other observation I want to make beyond it, if I might. Okay, thank you. I'm going to promise you what I promise every litigant. And I hear a litigant before me asking for an overturning of a precedent. That's what I hear. And I hear arguments for that. And arguments for overturning precedent include changed circumstances. Okay? And that's what I'm hearing. That's the kind of nature of argument I'm hearing. That's something a judge takes seriously, of course. Always. And any litigant can come to court and argue anything. That's the beauty of our system. I will follow the law of judicial precedent in this area and every other area put to me. I will make no promise for the result in any case. That's not what judges do. We listen to the cases put to us.
And for the record, it's not what I want you to do. What I want you to do is to tell me that if the proper decision is that this was so wrongly decided it should be reversed, you'd be willing to go there based on proper judicial decision-making.
I will follow the law of judicial precedent in this and every other area, Senators, my promise to you. The other thing I would say that I would like to say is two other things. One is there's room for not just for their litigation, Senator, but legislation. in all of these areas. If there are changed circumstances that Congress observes, it's free not just to bring a lawsuit, but to pass a bill
Here's
on
the
any
problem.
of these areas. And finally, Senator, may I just finish?
You finish, but then let me come back to that
Of course, of course. The last thing I want to say is I'm distressed to hear you think that judges or the Supreme Court is an organ of a party. That to me is just, I know you feel that way, and that distresses me.
It distresses me too.
And I just don't.
Quite a lot.
I just don't see judging that way. And I don't see our rule of law that way. I don't see Republican judges and I don't see Democrat judges. I see judges. And Senator, I think the rule of law in this country works. And it works so well that to speak like that diminishes what we have. And it is, for me, a failure to appreciate the beauty of our system, that we resolve hundreds of thousands of cases a year, almost always unanimously as judges, that the disputes are limited to a fraction of a fraction of a fraction of a percent, and that once we resolve them through the dispute process of litigation and we have precedent, that settles that problem and we can move on to the next one. It's a miraculous system, really.
In my time that remains, which is getting briefer and briefer, let me make 2 points. One, on the 10th Circuit, I don't believe you hardly ever have party line decisions made by your court. We looked, and I count only 2 in the entire time you've been on the court.
I really appreciate you
It's a
pointing that
very
out.
different-
Thank you.
It's a very different world where you are. When you get to the Supreme Court, now we have these 5-4 decisions that I pointed out, and it's 6-0, one party over the other party's interests at the polls. It's 16-0, corporate interests versus human interests in litigation. There is a point where it becomes reasonable to discern a pattern, and I see a pattern, and it distresses me. Now, the point that I wanted to get back to, I've got 2 minutes left, was your question about Congress can do this. Congress can rewrite these laws. Congress can demand disclosure. Here's the problem. In the same way that a small competitor can be crushed by a dominant business in the economic market, once you let certain political interests achieve the kind of dominance that Citizens United has let them get, they can start to exert disproportionate control over Congress. And now Congress can't do that any longer because there's no longer a fair playing field. If the court can rebuild a fair and competitive playing field, then maybe we can do something about it. But to say to Congress that you should solve this while at the same time the court has put Congress in a position where it can't solve it because the unlimited power and the secret money of these interests is such a powerful and pernicious effect, is something that I'd like you at least to be thinking about as a point if you get to that court. I hope you will take that sincerely. You are quite expert in antitrust law. You understand that principle in the economic sphere. I urge you to consider that Citizens United has caused that to happen in the political sphere. And with that, my time has expired.
I would like to, if I might, just briefly,
You
Senator,
can proceed.
just cheer you up a bit, I hope, about the judicial process. I think that you're right that there are some 5-4 decisions. There are. But what that overlooks, I think, Senator, are some facts that I shared, I hope, with the American people yesterday. That even at the Supreme Court, where they take the 70 or 80 hardest cases every year, where circuit judges have disagreed, and even then, only about 5% of cases get to me. So we're talking about a fraction of 1% of the cases. That they're unanimous with 9 justices appointed by 5 different presidents 40% of the time. It's a remarkable thing. We should be proud of it.
I understand that, and I get it. But what we have as a right is to have the Supreme Court make a fair decision in every case.
I agree.
Not just 99% of them, but all of them. And I think these 5-4 decisions are a problem. You said earlier that sometimes, I think I'm quoting you correctly, sometimes big corporations can capture an agency. That's a well-known principle of administrative law and of economics. just let's be sure that our Supreme Court doesn't get to be one of those agencies that's captured on any subject.
Nobody will capture me.
I hope not.
We will recess now until
Wow, that's a good line to recess. on.
until 1 minute after 1. Okay.